Fair use is a legal doctrine that permits the unlicensed use of copyrighted works in particular circumstances. Allowable uses include criticism or commentary, including parody. Although some cases are straightforward and uncontested, for many others it is anything but. Copyright law provides a set of factors for answering whether a use is fair, including the purpose and character of the use. The Supreme Court explained this encompasses whether the use is transformative. In that case, involving the song Pretty Woman, the court held that a rap cover which interspersed off-color commentary to the song did provide a new meaning or message and was transformative. But if an artist takes a photograph, adapts it to their own style, and licenses it for a magazine cover image, is that a parallel case? Or does the artist need to pay royalties to the original photographer? What if they paid a royalty the first time? Do they need to pay a royalty every time? A recent case, Andy Warhol Foundation for the Visual Arts versus Goldsmith, required the Supreme Court to evaluate this issue. In 1981, Lynn Goldsmith took a picture of the musician Prince and subsequently licensed it to the magazine publisher Condé Nast as an artist's reference. Condé Nast then hired the famous pop artist Andy Warhol to create a magazine cover based on Goldsmith's photo. Warhol created a series of 16 images in his famous style, one of which was used in the article Purple Fame in Vanity Fair in 1984. When Warhol died in 1987, the Andy Warhol Foundation took ownership of Warhol's copyright. Flash forward to 2016. Shortly after Prince's death, Condé Nast contacted the Andy Warhol Foundation about using one of his Prince images for a commemorative magazine. Condé Nast paid a $10,000 licensing fee to the foundation for use of the artwork, but did not pay a license fee to Lynn Goldsmith. Goldsmith saw the magazine cover and a lawsuit followed. Following litigation, the U.S. Supreme Court agreed to hear an appeal based only on one of the factors, whether the use is transformative. Justice Sotomayor wrote a majority opinion for the court, finding that it was not. As an initial matter, she found that Warhol's creation of the 16 images in 1984 and the 2016 license were different uses, and that the 2016 license was not transformative, even though the 1984 creation may have been. Accordingly, the relevant use was only the 2016 license. Although the Warhol image was an artistic expression, it was being used as a substitute in a medium where the actual photograph itself could have been used. And indeed, the majority opinion noted that a photo by Goldsmith of Prince had been used as a cover of a different periodical. Because the images served the same purpose, the 2016 license was not transformative. The original creation of 16 images by Warhol, rather than one, when Condé Nast paid a license fee directly to Goldsmith as an artist's reference, was not considered by the court, although it was suggested that it had been transformative and therefore acceptable under fair use. However, even if the creation had not been infringing, payment of a license fee to Goldsmith for use 30 years later as a magazine cover was still required. Most fair use claims rely on the defense of being transformative, but as the Warhol ruling suggests, transformation must go beyond a generalized invocation of providing a new meaning or message, and each infringing act is analyzed for transformation separately. What does that mean after the Warhol decision? What does the claimant need to prove? Does this precedent protect or stifle creative work? What are the implications for other mediums or platforms that involve intellectual property, like videos or internet posts that use pre-existing media? Join the conversation in the comments below.